5 seconds to go. Start. Reliance placed by learned counsel for the appellant on the decisions of this court in the case of Anita versus Godfather Travels and Tours Private Limited Supra is also totally misfounded in as much as the ratio descendi of the said case runs contrary to the argument advanced by learned counsel for the appellant. Stop. It may be relevant to extract the following observations made in paragraph 59 of the reports, para. In view of our aforesaid analysis, we arrive at the irresistible conclusion that for maintaining the prosecution under section 141 of the Act, arraigning of a company as an accused is imperative. Stop. The other categories of offenders can only be brought in the dragnet on the touchstone of vicarious liability, as the same has been stipulated in the provision itself. Stop. We say so on the basis of the ratio laid down in C.V. Parekh, which is a 3-judge bench decision. Stop. Thus, the view expressed does not correctly lay down the law and, accordingly, is hereby overruled. Stop. The decision is overruled with the qualifier as stated in para 51. Stop. The decision in Modi Distillery has to be treated to be restricted to its own facts as has been explained by us herein above. Stop. Para. As already stated above, a perusal of the complaint goes to show that even though respondent number 2 has been arrayed as a respondent, but there are no averments that respondent number 2 at the time when the offence was committed was in charge of, and was responsible to the company for the conduct of its business. Stop. The averments made in the complaint are being reproduced hereunder. Para. Complainant makes the following written submissions. Stop. That the complainant has a firm which deals in all types of materials used in the machineries of factories. Stop. Defendant's firm Messrs. Ravi Organics Limited is a chemical factory and the materials used in the machinery of defendant firm are supplied by complainant. Stop. Both the firms have all trade relations and they do business with each other. Stop. Defendant gave an account pay check bearing number 802276 of Union Bank of India, Muzaffarnagar of rupees 10 lakhs on 20th November 2012 to complainant against outstanding bill and asked him to produce the same in his bank for encashment after receiving his signal. Stop. Para. After laying up claim many times by complainant, defendant on 15 December 2012 asked the complainant to produce the said check in his bank for entrenchment after 4-5 days, it will be cleared, complainant believed the defendant. Stop. Para. On 21st December 2012, complainant produced the said check in his bank, State Bank of Patiala, Court Road, Muzaffarnagar, for encashment in favor of his account. Stop. On 24 December 2012, he was informed by his bank that the check amount exceeds arrangement made on 22nd December 2012 by defendant's bank, that is, Union Bank of India, and thus, the said check was dishonored. Stop. Para. Upon dishonoring the check with the remarks of exceeds arrangement, complainant issued a registered notice through his advocate to the defendant at his above given address, which was received by defendant on 1st January 2013, but even after lapse of 15 days, defendant has not made the above payment to complainant so far. Stop.